Aloha and good afternoon, everyone. Welcome to the Senior Council Division Coffee Hour for June 2026. I'm David Rotz from the SCD Board. I have the honor of introducing this month's guest speaker, Timothy Midura, an accomplished attorney, advocate for animals, CPA, speaking to us on estate planning for pets. I want to maximize Tim's time with everyone today, so I'll turn things over to him in just a moment. A couple of housekeeping notes. We are recording this presentation. It'll be up on YouTube on the Senior Council Division page there, so you don't have to jot down everything. And Tim has graciously agreed to accept questions. Best way to submit them, please, would be in the Q&A box, and I'll do my best to monitor those questions and mention them to Tim as they come in. So with that, Tim, I'll turn things over to you, please. Thank you.
Wonderful. Thank you for allowing me to take some of 30 to 45 minutes of your day to talk about something that is close to my heart. Let me get my screen sharing going to the slide deck. And here we go. So estate planning for animals. So what if 2/3 of your clients all came to you with special needs child in their immediate family? Would that change the way one approaches estate planning? And the answer there is yes, based on the demographics. So who are loved ones? Loved ones are family members, human family members. It could be charities, and certainly there are interspecies families where individuals look at their pets, their non-human family members as family members. So the majority of your clients have some kind of pet as part of their household. They're companion animals. The paradox and the conundrum of having animals within your household is that at law, they're tangible personal property, yet they are living beings. They're dependent. They can suffer. They have anxiousness. And of course, they are perishable. So time is of the essence as living beings in dealing with them. And having effective and efficient estate planning documents is quite important to handle these special living creatures. In many respects, as deemed to be tangible personal property, they're really no different than a kitchen toaster at law. But what happens when somebody dies? If there's not a neighbor, a friend, a family member to pick up the pet animal, the animal could be turned over to animal control or an animal shelter. And in that context, if abandoned, could become subject to euthanasia. Estate planning for animals, as far as being integrated into estate planning documents, is really quite rare in my experience to see. And the question is why is it so rare? One is that lawyers and financial planners just don't think about how to ask or properly integrate animals into the estate plan. They're not financial planners and lawyers are really not asked about it by their clients because that's not on the forefront of their minds when they come in. They're just not thinking about it. And lastly, lawyers do not know how to effectively facilitate estate planning for animals. But getting a dialogue going, even a short question on the estate planning questionnaire of, do you have animals or pets that you consider to be family or for whom you would like to make specific planning? That just starts or just allows you to jump over, do you want to do estate planning for animals as far as the client's concerned? So at law, animals are deemed to be tangible personal property. One of the common processes in estate planning documents and is as part of the package is to have an assignment of untitled tangible personal property into the revocable living trust. And when that general assignment is created and signed by the client, it was interesting when it dawned on me, oh, that's sweeping the animals in the household into the revocable living trust. And I wonder if the trustee, who may not be the settlor, really understands that. That was an interesting nuance when it dawned on me some years ago. So planning overview is there's two general pathways of documenting interest of animals in the estate plan. One is to use boilerplate in documents, which is my high recommendation for almost every estate plan that's created by a lawyer. And then there's the aspect of enhanced planning and drafting, which includes a pet trust integration, which we'll talk about more soon. As far as recommended boilerplate provisions, I think boilerplate provisions to cover animal interest should be put into the financial or property power of attorney, into the will, and into the revocable living trust. The boilerplate provisions that I generally recommend are a general coverage of care, maintenance, support, health, and general well-being of the animal. It also include whether neutering or spaying is authorized, hiring of caretaker, authorization to board an animal, acquisition of insurances that may be appropriate to enhance the quality and dealing with the animal's interests. Adoption out or the surrender to a quality shelter should circumstances warrant. Whether under some dire circumstances the animal could or should be euthanized. And what if the female pet is in gestation with pregnant with an offspring? What do we do with that offspring? How and should that be covered? And then lastly, some discretion at least to create a pet trust, because otherwise the fiduciary will not be able to create a pet trust unless it's in the fiduciary powers. So when we're dealing with an estate plan, we're naming fiduciaries, and typically it's an executor of the will, trustee of a trust, and a financial agent for a power of attorney. And one thing to ponder on is, are these individuals that we name for the general estate administration process, are they individually the better person to handle pet interests? As an example, if you have a child who has an MBA and is really financially astute, but doesn't like animals, is that the right person to handle the animal interests? And so there might be some carve out of who should be the fiduciary for animal interests. And this is where we get and transition to pet trusts. So, animals have some common characteristics with a disabled human child. There's a legal incapacity, there's a dependency, there's certainly communication issues, and there's often unique physical, mental, emotional, and behavioral characteristics. And in this context, the best way to really grasp the concept of a pet trust is that it's like a special needs trust or a supplemental needs trust. And if you think about it that way, I think you will inherently understand how a pet trust works or can work and integrate. What's unique is that about a pet trust is that the pet or the animal is not actually a beneficiary. The animal is instead a purpose of the trust. So to have a binding, authorized, legal pet trust, you have to have a specific law that enables it. And these laws are generally referred to as honorary or purpose trust laws. And so a pet trust is a form of an honorary or a purpose trust. And of course, then Hawaii does have a pet trust law that will cover designated domestic or pet animals. One of the things unique about Hawaii is that it is in the minority of about 12 states throughout the United States that restricts animal trusts to domestic or pet animals. So only Hawaii and about 11 other states restricted. All the other states, the majority of states, allow it for animals as a general category as far as animal trusts. Um, the Hawaii Pet Trust statute does not define what a pet is. And so, generally, I view it as a household type of animal, some animal that's not for commercial or consumption purposes. Hawaii's criminal code defines pets as examples: dog, cat, domesticated rabbit, guinea pig, domesticated pig, or caged birds. And for birds, you can think about, and caged birds, there's all these fancy words that are on my screen, but in some, it's like it excludes chickens as an example. Um, the Hawaii statute says that pet trusts can be liberally construed to carry out the settler's intent. And this also means that extrinsic evidence is admissible. And to the extent that the estate planning process and the estate planning documents are more particular and definitive, it really makes advancing a pet trust easier and more seamless. A pet trust terminates, generally speaking, when there is no living animal that is covered by the terms of the trust. And then generally the trust instrument itself will dispose of the remainder of assets that are in the pet trust. Because the animal is not a beneficiary and certainly cannot enforce the terms of the trust like humans as beneficiaries can enforce their beneficial interests. The statute provides an enforcer, which will be a human or some organization that can be named in the trust to watch what's going on as far as the trustee taking care of the animal and operating in accordance with the terms of the trust. We use the term enforcer because that's what the statute talks about, somebody to enforce. If you think about the concept of a trust protector, there's really no difference between a trust protector and an enforcer. Sometimes when I'm drafting a pet trust, I will have an enforcer with certain roles, and then I will have a trust protector for other elements that may be more broad than the enforcer and than him or herself. It's important to note in creating the pet trust that a court may reduce the amount if that amount is deemed to exceed the amount required for the purposes of caring for the animal. And this becomes important again in designing the pet trust and the estate plan as a whole so that remainder beneficiaries are not in a position to argue for reducing the funding amount. And I have a few examples of that kind of reduction a little bit later. There's no specific requirement for accountings or filings or reportings on a pet trust. And this is where the trustee and the enforcer and perhaps any other third party of interest, such as the caretaker, might advance interest if the administration of the trust is not going well. A pet trust is exempt from the rule against perpetuities. Duly noting that, animals that might be subject to a pet trust, horses can live for 40, 45 years, parrots, 75 years plus, tortoises, 100 years. It's just a comment of, you have to design, really know who is this trust going to be designed for as far as the animal species, what's that species life expectancy, and plan accordingly as far as what amounts will be necessary. So the most important elements of designing and implementing an animal trust is designating and identifying the animal of interest. And does it include offspring if it's a female animal? Articulating standards of proper care, determining reasonable and necessary financial funding. And here's where life insurance might be necessary to get the funding that somebody needs, and enabling and naming the proper team and their potential successors. These are all things that need to be discussed with the client in designing the overall estate plan that includes interests of animals and, of course, the pet trusts. So, we have these actors, trustee, a caretaker is always assumed. A trustee may be the caretaker, the enforcer may be the caretaker, but certainly there needs to be someone who's taking custody of the animal and advancing the animal's interest for the animal's lifetime. And then there's a possibility of having an augmented aspect of a trust protector, which many estate planners are used to incorporating. But consider any conflicts of interest between the named fiduciaries. Are they really the best person to manage the animal interests? And are there disqualifying characteristics? They may not be an animal lover, and they may have a conflict of interest being a remainder person. There are general questions of, do the documents, such as a power of attorney, do you include the animal interests power provision within the general power of attorney, or do you have a separate power of attorney and then two powers of attorney, the general and the animal power of attorney, are they coordinated? Is the animal going to be in the trust as far as the corpus, or is the trust going to be for the benefit of the animal who someone else has custody of that? So there's some, general questions along those lines. Threshold questions include, what's the funding amount that's going to be put in for the animal? Who is going to be the involved fiduciaries? And then again, considering any conflicts of interest. One of the aspects about a pet trust, it's just very, very practical, is a pet trust is not income tax exempt. It's not like a charitable remainder trust, as an example. It is just a regular trust, and so it's subject to all the regular income tax rules of trust. Since there's no beneficiary of the trust, there's no D&I that carries out income. So it's a complex trust, if you understand that concept, for Form 1041. And there's no charitable deductions for contributions into the trust, whether it be income tax, gift, or estate tax. So financial funding is often likely a surprise. Some people may think, oh, if I put $3,000 into some kind of a trust or set aside, but if you consider the particular animal species, breed, age, including life expectancy and aging characteristics, the standards of proper care, and then of course compensation of the humans that are going to be involved in taking care of the animal and processing the trust during the trust lifetime. The dollar amount of funding really can be surprisingly large. And that, of course, and what large means, varies. So developing a financial funding number is a goal, but the most important thing is the process of determining that number is important because it really evidences the reasonable and necessary number. The number may be larger, but if you have the memorialization of the process and what the standards of care are and the like, then there's a justifiable aspect of that funding number, because a remainder beneficiary may have a conflict of interest of saying, well, if the animal doesn't have the benefit of that dollar amount, then I, as remainder beneficiary, would get it. Articulating standards of care are really important because they justify the funding amount and they control the expectations of the remainder beneficiaries. The court can look at the standards of care. Experts can come in and talk about these articulated standards of care represent these dollar amounts during the lifetime of the animal. It's nice to have all that built into the four corners of the document, developing the purpose of the trust. And then because everything's built into the four corners of the document, the ability to attack the funding as being excessive is more remote. General standards of proper care, cover physical, mental, emotional, behavioral, and of course the human support needed to facilitate these elements. I'm not going to read this page here, but here are some articulations of standards of proper care. You can go back and look at the slide deck that you've been provided with if you want to read through those for some ideas. And then beyond just standards of care, talk about standards of well-being. Again, more verbiage you can look at later. Other considerations is whether under certain dire circumstance should the euthanization of the animal be permitted. Duly note that as tangible personal property, the animal is in fact an asset of the estate. So euthanization is really destroying an asset of the estate, to say nothing of the life and just the life of the animal itself. Pregnancy, only 2 states have their statutes expressly recognize animals in gestation. So you can basically draft in, should the female animal be pregnant, the offspring should be covered by the terms of the trust. And whether neutering and spaying of the animal is appropriate, again, you're changing, if you will, the value of the subject animal. So if the animal is a breeding animal, this can be very important as far as that valuation aspect. But also with regards to neutering and spaying, it's a way of not having offspring, of course, to complicate things. Care of animals, and just remember that what we think about care, as far as if you're not an animal person, we as lawyers, we really don't know what it takes to take it takes for the care of animals. There's the concept of dog years. So a dog versus 3 years old versus 9 years old. At 9 years old, maybe running towards the end of his or her life expectancy, and the care, such as teeth cleaning. We hopefully brush our teeth at least once a day, but animals certainly need teeth cleaning and grooming and things like that fairly often. We lawyers, we really do not know how to properly design the intimate aspects of articulating care. And so it's up to the client and perhaps a team of people to help the client articulate those standards of care, and thus determining the financial funding target. In other words, I don't take even though I have sample language for a client to use or to evaluate, and that sample language and those elements of care, I've gone over with care providers like veterinarians and the like in developing that language. I'm really not the expert, and I certainly can't direct my client as far as, isn't this what you want? It's a matter of what does the client want and what are the client's resources, financial resources. It always helps to create a demonstrative budget over a period of years. The animal's life expectancy, based on the species, and then maybe add a few years, like a 5-year budget, because expenses of the animals, just like with humans, may go up over time. Who the remainder beneficiary is of the animal trust, and that really usually means who is the remainder beneficiary of the estate plan. It's important to ask because those remainder beneficiaries may be the ones who are likely to attack the funding as being excessive. So I'm going to give you 2 examples of financial funding failure. The first one is pretty commonly known, and that is Leona Hemsley's estate, where Leona put $12 million in trust for her dog named Trouble, which created trouble with the family. And there was a big court process, which finally resulted in the court saying, we're going to reduce the $12 million to a much more reasonable amount of $2 million. That's a lot of money still, $2 million, but it's not what Leona wanted at first. And so we question of, um, if she had drafted with more specificity, what kind of apartment on Fifth Avenue she wanted trouble to have and the like, maybe the court would not have reduced it so much. Out of Tennessee, this was pretty stark to me. This is a Tennessee case um, where Bill Doris uh, bequeathed $5 million to be put into trust by the executor. But that's all the will said. Put, hey, executor, put $5 million into trust for my dog Lulu. Nothing more was said. And so there was no articulation of standards of care and the like. Um, so so the executor didn't really understand why so much money would be there. There might have been other issues of maybe there wasn't as much money to take care of remainder beneficiaries. And so the executor got together with the remainder beneficiaries and they went to court. The court appointed basically a guardian ad litem for Lulu. And the court finally put an order in that the pet trust would be funded with $30,000. So that going from what Bill wanted, $5 million, down to $30,000. And if you looked at the court documents, everybody was pretty proud of that 30,000 because they basically said, well, we've analyzed the care for Lulu for her lifetime. We think it's about $21,000. So we're going to be generous and we'll put $30,000 in there. And, certainly the remainder beneficiary is much happier because they got the excess of the 5 million over the $30,000. So common threads of financial funding failure are not articulating the standards of proper care with definitiveness, not considering what amount is actually reasonable and necessary in the totality of the circumstances. In other words, really ask the question, what might be too much, as well as what might be too little. Some, like Bill, probably just when he said $5 million was just too much. Leona may have said too much. On the other hand, if they had articulated the standards of care, what the team was going to look like, what the living conditions were going to look like, those amounts may have been much more reasonable. So also not memorializing the determination process and the real intentions. In other words, creating the justification for the amount within the four corners of the document, and perhaps providing a fail-safe clause in the event of excess funding. And I'm going to describe that in a moment. So if the remainder beneficiary objects to the excessive amount, what can we do to fight that? One is we can basically put into the document that if there's an excess funding determination, that the remainder beneficiary does not get it, but perhaps the designated caretaker gets it instead. It's a disincentive. So if the remainder beneficiary, it's sort of like an inter arum clause. If you object, you're not going to get it anyway, kind of a thing. So an excess amount could be said within the document that goes to a caretaker, and the caretaker will take that money and take care of the animal. Or it could go to a favored animal shelter or other animal charity. Or somebody could be given a power to appoint the remainder if there's an excess amount. So these are some disincentive ways of having the remainder beneficiary be a little bit more sober about attacking the funding amount. Articulating the dollar amount is really quite important. It should be, I think it should be a pecuniary amount in a testamentary, as a testamentary limit. If you give an unlimited discretion to the trustee or the executor to fund a pet trust, it just can create all kind of frustration and anxiety. It could cut into marital and charitable deductions. So don't have it so that it's totally discretionary up to the trustee, unless, of course, that discretion has a top dollar limit, such as any amount up to $50,000. That way, we know what is available for other purposes beyond the $50,000. Beware of drafting outside of the enabling statute. So, for example, for Hawaii, since Hawaii is restricted to domestic and pet animals, you cannot cover farm animals, as an example, or an animal that might not, under Hawaii law, be deemed to be a petable. So it's sort of like, is a chicken is the favorite is the pet chicken that you're not raising to consume, is that a suitable animal? Well, if you generally speaking, maybe not, based on what like the Hawaii Criminal Code defines as being a pet. But since the Hawaii statute says that the trust should be liberally construed, and if someone really were to say, Betty, my chicken, and put a photo of the chicken there, is considered to be my pet, and I want Betty taken care of by this pet trust, chances are that would stand up because it's so specific in that regard. What about after acquired animals, offspring of a female? What about continued coverage by the trust when there's an adoption out? These are things that are not specifically covered by Hawaii statute, but should be drafted in, and I think would be upheld based on just the ability to have a trust liberally construed according to the grantor's intention. What are the triggers on funding? It could be the settler's incapacity. It could be certainly the settler's death, and articulated as a specific gift. While the grantor, the settler, is alive and has capacity, certainly the grantor can take care of their pet animal themselves without trust, the fiduciary discretion. You have to look at, what assets are available. What are the liquid marketable assets? What are other assets pools that are out there? Can the fiduciaries access those assets and the like? So there needs to be a common sense aspect of what are the facts and circumstances financially. Again, what are the pots of the assets? Also, insurance might play into this. If somebody doesn't have much in the way of assets, but just like with planning for children, life insurance may become a funding mechanism. Clear identification of the subject animal. The Hawaii Trust talks about the designated domestic or pet trust or pet animal, the designated. And so you have to be clear about what animals are going to be taken care of. And if it's not a particular animal who's alive at that point in time of creation of the trust, again, be very, very clear of who's going to be covered as far as an animal. Also, there's an aspect of what I call being a paid paranoid. I often refer to myself as a lawyer as being a paid paranoid, being paranoid on behalf of my clients. And that is, there could be some circumstances where somebody is very generous to take care of, say, a German Shepherd dog. And over the course of time, you find that the German Shepherd dog is now 35 years old, which of course is not possible in reality. But the caretaker kind of says, hey, okay, the dog died, but I'm going to replace the dog because this is a sweet gig taking care of the dog, getting my compensation for caretaking, and it's an easy thing, and the dog's really my own pet at this point in time. And so really, articulating, who is this animal? How do you identify the animal? Should there be, certainly there should be at least annual veterinarian checkups, but whether the veterinarian, reports back to the trustee and to the enforcer, that the caretaker has the original intended designated animal. So successful design and implementation, clear designation of covered animals, intentionally tailored to specific animal characteristics. In other words, just not something that's very generic, but is this a parrot? Is this a tortoise? Is this a dog? Is this a horse? Is this a pig? What are the characteristics of the species and the like? Uh, Care standards, named fiduciaries are important to articulate. Practical funding with a demonstrative budget backing that up, and all complying with an enabling statute. And to bring all of this together, it really requires a team, us as the lawyer, the client, um, who's the owner and the guardian, and a professional care professional, whether it be veterinarians or, as they say, sometimes dog walkers and the like. It'll probably take a team to really build out the best design. So, what happens when a pet trust is not really viable for a number of reasons? Well, you can specifically gift the pet away with some dollar amount. Certainly have boilerplate provision as I've already articulated. And in the boilerplate, I've already gone over the various characteristics that I personally recommend. There could be some ancillary, not legal, but ancillary benefit enhancements that you can suggest to a client. Can have notice cards, such as something in the purse or a wallet that says, if somebody is in an accident, they find themselves in the emergency room, first responders are processing things. There could be a card in the purse or a wallet that says, I have a pet at home. I need a care, and my emergency contact for pet care is so and so. There could be a posting on a door if first responders have to go into a house to say, I have a cat inside, I have a dog inside. Don't just ignore that cat who's hiding. And there could be information sheets for either the caretaker or for first responders that talks about animal information. Here's the vet information. Here's the contact information for a temporary caretaker. Here's the insurance records and the pet insurance and the like.
Sorry to
Now,
interrupt, Tim, but do you mind if I jump in with a question we just got in the Q&A
absolutely.
box, please? Okay, thanks. So, in determining the funding amount, do you normally have a formula clause based upon the age of the animal at the settler's death as opposed to a set amount?
I would suggest a set amount that just like, uh, people's children, every 5 years you reevaluate. If this is important enough, um, you know, have somebody reevaluate it. When I'm drafting, and this is a generic approach to what I call better estate planning design. When I am drafting, designing and drafting, not a pet trust, but all of my estate planning documents, I have three hats that I wear, and I change them in the process of the design and the drafting. I have my estate planner's hat, my draftsperson hat, which is, okay, here's what I want to accomplish. I'm going to draft the best language I possibly can. Um, and the question is how do I draft that best language? And sometimes, for example, in doing so, I'll say, I'm going to draft actual words. Then I'm going to add in an example of what I want, and then I add in a statement of intent. That could go all into my drafting. I'll take off the draftsman's hat then, and I'm answering the question in this process way. Then I'll take off the draftsman's hat, and I'll put on a new attitude that I call the administrator's hat. And I ask myself independently, can I administer what that language says? Is it under various circumstances, can I really administer it? And if I cannot administer it, if there's ambiguities on the administrator's hat, I'll go back to drafting and fix it so that the administrator's hat works under the draftsman's hat provisions. Then I'll take off both of those hats and I'll put on the adversarial hat. And I'll ask myself, as an adversary, how can I poke holes through this? And if I can poke holes through it, then I'll go back to hats 1 and 2. That's my way of saying, can I well enough draft a sliding scale for a species with a particular animal's generic characteristics based on their current age, based on, if an animal is not getting high quality care, their life expectancy is probably less. If they're getting better care, it's probably more. If the animal is, a cat versus a horse versus a parrot, that life expectancy formula stuff just doesn't work at all. So the real answer is, what are the facts and circumstances, and how do you make it work? And in that context, this is where I think as a lawyer, you have to just kind of say, okay, talk to the client. How does this work? Can you, client, go to your vet and sit down and say, what might be under these circumstances today, the life care number? What might it be? I, as a lawyer, don't know that. And I don't know if I can draft a formula. As a matter of fact, I know I cannot draft that formula. So the answer is, it's a process, and it's facts and circumstances dependent. And the client may not be able to or want to pay for the whole process. So how do it's the art of the practice of law, so to speak. And what happens when you find out that there is a child with a special needs versus, or a spendthrift child, or a child with dependency issues? Things go sideways so quickly. And these kinds of animal trusts could be simpler. It's a dog. We're going to put, like, for example, one of my clients who was extremely wealthy, we started out kind of a fun negotiating. I don't negotiate with my clients, but this was kind of fun. He started out by saying he has these two animals, were always his interest. And so when we were planning his pet trust for his two dogs, and his animals were always his family. He started out by saying, well, what about $5,000? And I just chuckled to him. I'm not telling him what to do, at least in this. I started out not in this case. I said, I'll call him Bruce. I said, Bruce, with the amount of money you have and what you want for your animals, $5,000 is nothing. So we went to 10, we went to 15, we went to 20, we leapfrogged to 50. And then finally I just said, whatever is left over for your family of animals is going to go to the same charity at the end. Why don't you just put in $250,000? And then, because we know that's going to work. And your remainder beneficiaries are going to be happy in any event. They're not going to, we know we're not going to argue over $250,000 when they're going to get the remainder. And so that is kind of a ludicrous example, but it was a real example. But if we stopped at 50,000 or 25,000, certainly if we stopped at 50,000 or 100,000, that would have been very okay. This is someone who had, kind of a Leona Hemsley wealth. So we weren't starting with 12 million.
Very helpful. Thank you. And just a quick note in response to some other comments we're getting before we have you go on. We will be sending your slide deck and a link to the YouTube video to everyone who's registered.
All righty.
Thanks.
Actually, I'm at the very end. You can go to this website. Again, this will be on the slide deck. Um, if you want sample boilerplate for powers of attorney, trust, or wills, I have it there, what I actually use. I have a checklist for drafting a comprehensive animal trust. I have a sample comprehensive animal trust. Um, what I want to do is to provide for other lawyers the tools necessary to actually facilitate the type of planning that I'm suggesting. So I get back to my original question. What happens if two-thirds of your clients came to you with a special needs child, which happens to be part of the interspecies family? And the bottom line is be intentional about introducing estate planning for non-human family members. It can be as simple as write in the estate planning questionnaire a question. Do you have an animal part of your household that you want to do special planning for? Um, that's that's a good place to start. And you may be surprised that how many times the person will say yes. I would say that having good boilerplate in the will, the trust, and the financial power of attorney will actually resolve 90% at least, probably 90% of people who want to do something because it gives the flexibility um, to the fiduciary to take care of the animal, to create a pet trust um, with a limited dollar amount that's determined by the client. Um, and then what if a client wants to do an actual pet trust? Again, you have the theory that I've just gone through, and you have all the forms that I would use to create the actual pet trust. So thank you so much for listening to me. And if there's any further Q&A, I am ready for those.
Yeah, thank you, Tim. We do have at least one more question, and just I want to thank you for a very fascinating presentation. I appreciate you making it practical and tangible for us, in particular in Hawaii, by citing the HRS provisions. And that actually relates to the question. You mentioned Hawaii is in a minority of states that limits the types of animals that can be subject to a trust of this nature. Would you recommend to animal advocates who lobby at our state legislature to maybe consider in the next legislative session expanding the statute to be consistent with the majority of states?
Uh, I'm not a legislative expert, but I guess the general question is why do the other jurisdictions have broader coverage? Um, that's a rhetorical
Hmm.
question.
Hmm.
Um, one planning characteristic is somebody could say, um, okay, I'm creating a pet trust, but I want the trustee of the trust to be in California. Actually, California, I think, is wrong because they have a pet limitation too. Um, Oregon as an example, um, where I want the trust in Oregon. So it's not under Hawaii law. You're choosing a different situs for the applicable law. I think that's doable.
Okay, great. Thank you. And I do want to apologize to the folks who had audio trouble. I'm glad we got the recording and we received some comments that the captions and the slides were very helpful, even for those who didn't have the audio. So, once again, Tim, we really appreciate you helping us today. Great to have you
Thank
with
you
us.
for the honor of allowing me your time.
Aloha. Thanks, everyone.